With all of the new commission lawsuits that continue to pile on, I think it's very important that we do a quick reset and really understand what it is that we're talking about, really frame what we're up against. We as real estate agents also have a little bit of a glimpse at what could happen, and certainly some things that we could be doing in the meantime to adjust to the new norm as we see it coming. So what we're going to do today is we're going to react to an Inman article by Bernice Ross, who does a phenomenal breakdown. We've done a previous breakdown before from another publication, which is really, really detailed, and I really appreciate that component of it. This particular one is going to give you an even more summarized version that's going to give you really a good glimpse at why things are happening, what has happened up to date, and what can potentially happen in the future, along with some tangible things that we can do as real estate agents to prevent, well, maybe not prevent, but to better insulate ourselves within our business. So let's do this. All right, the Agent's Essential Guide to the Commission Lawsuits. So again, this article is courtesy of Inman.com. So the author, I really need to highlight her writing because she's phenomenal. Author and trainer Bernice Ross provides the rundown on what to know, what's likely to change, how it may impact your pocketbook, and steps to take to be prepared for what's ahead. So she has something very, very practical, and I think you're going to appreciate it. So let's get into it. All right, so commission lawsuits in a nutshell. There are 4 sets of lawsuits that are at the heart of the so-called bombshell commission litigation. You have Setzer Burnett, Morrell, Nosellic, and Batten 1 and 2. So as a quick little recap here, because it doesn't go on to explain this, there are over 20 plus commission lawsuits that have named NAR. There are several, there's a handful that have not named NAR, that they've gone mostly against local MLSs or brokerages themselves, but haven't named NAR. So again, it's only a handful. So altogether across the country, I would venture to guess there's about 25 to 30 commission lawsuits that are all basically alleging the same thing. But the 4 primary ones that are going to have instrumental, outsized implications to the entire way that we do business are these 4 that Bernice is alluding to. These lawsuits, along with all copycat, let me see, here we go. Let me move this. All right, so all lawsuits along with all the copycat litigation come down to 2 single issues: NAR's cooperative compensation rule and mandatory membership in NAR to access the MLS in many areas. Defendants in these suits are charged with violating antitrust laws by colluding to fix prices, aka the commission rates. As a result, sellers allegedly paid much higher commissions than they would have paid had buyers been responsible for directly compensating their own agents. So what is this saying? So there's been some collusion. So there's been some price fixing in the sense that, according to these individuals, through NAR's practices and other brokers' practices as well, there was some collusion that we as agents had a little secret plot to not reduce our fees because we were all holding firm, holding the line, saying you must charge this or nothing. So really keeping the commission rates at a high level without allowing them to go down and allowing for competition to happen. So that's where the antitrust law comes through or gets alleged. Now, of course, we know that that's not the case, given that agents, and let me rephrase that, given that the clients are able to negotiate every which way, they just didn't see it that way, they being the people that brought in this judgment. Judge Bowe's ruling in the final verdict amount in the Setzer Burnett lawsuit litigation is expected sometime in April. So we're coming up on this on April very, very quickly. At this point, the 2 remaining defendants, NAR and Berkshire Hathaway Home Services of America, Anywhere, Keller Williams, and RE/MAX have settled both Setzer Burnett and Morrell lawsuits. So I believe Anywhere settled for, I want to say $85 million. Keller Williams settled for $70 million, and RE/MAX settled for $50 million. I want to say those are very close to the numbers that ended up happening. So you had Anywhere and RE/MAX. Let me rephrase that. There's 5 folks that went in, so 5 entities that went into the original or the biggest litigation, which was Setzer Burnett. You had NAR, Berkshire, Anywhere, Keller Williams, and Remax. So those were the 5 that were named in the original lawsuit. Two settled before the actual litigation. That was Anywhere and Remax. They settled ahead of time. So again, Anywhere, I believe, was 85 million. Remax did about 50 million in its settlement. Then after the litigation was lost in this case, and you'll see the amounts that we're talking about, NAR, Berkshire, and Keller Williams were the ones that were still in the lawsuit. Keller Williams, about a month ago, settled for 70 million. So the only 2 that are left right now is NAR and Berkshire Hathaway. So there's a tie back to this, because this, even though they settled, there is a loop. I don't want to say loophole, but there's something that I believe is undefined right now. And this is something that Bernice alludes to, which I think is very important, that a lot of folks are missing. We'll have 30 days to post a bond large enough to cover the amount of the verdict. Failure to do so usually forces the defendants to settle with plaintiffs, or in some cases, declare bankruptcy. That's pretty huge. Now, do I think that this is going to declare any of these brokerages and NAR are going to declare bankruptcy? I don't think the brokerages are. I think there's going to be a settlement. And if there is going to be a bankruptcy in the future, I actually think it's going to be NAR. If there is, I don't think that that's the case, but if there were, I would put my money on NAR. All right, so flying under the radar is Batten 2, the mother of all commission lawsuits. So this is where we get into that thing that's a little bit undefined. In November of 2023, Maya Batten filed a new lawsuit known as Batten 2 in Illinois. Like Batten 1, in this litigation, the plaintiffs are home buyers, not sellers. So you have an outsized litigation pool of, let's say, 85, 90%. We'll go with 90% of the lawsuits that are out there right now are all focused on the seller side. You have a very small fraction, 5 to 10%, that are focused on the home buyer side, that are saying that saying that the actual people that are affected are the buyers. It's not the home sellers. The home sellers aren't. It was actually the home buyers. So that's why the plaintiffs are coming in from the home buyer side, not the sellers. And then Inman called it the mother of all commission lawsuits. Now, here's what the complaint was. The anti-competitive effects outlined in the complaint boiled down to the following. Home buyers have paid inflated total commissions, which have been incorporated in the purchase price. So it's more expensive as a home buyer. The retention of a buyer agent has been severed from the setting of the broker's commission. The home buyer retains the buyer agent, while the home seller sets the buyer agent's compensation. This is a situation that the DOJ insists must be eliminated. We talked about this previously, where DOJ was suggesting a decoupling of the commission is what they were that was their verbiage. That's the verbiage that they were using. So the DOJ made that suggestion towards the middle of February that the commission should be decoupled, in their opinion, because of this particular reason. Price competition among brokers has been restrained. Agents are incentivized to steer their buyers towards properties that have higher commission homes, and the quality of buyer agent services has been reduced. So that's what they're alleging here. Now, this is where we get into the whole where the sellers versus home buyers, who's actually the affected party. This is where we kind of get into the situation that is often overlooked. The Batten complaints also point to the cooperative role as the source of these issues. A potential problem for the 3 entities that we talked about that have already settled, Anywhere to the tune of $85 million, Keller Williams to the tune of $70, and Remax to the tune of $50 million. Keep in mind, this settlement was to, all right, we're out of this lawsuit, but it's also meant to extinguish all copycat lawsuits. So here's where the situation that a lot of folks aren't necessarily bringing up comes into play. Is the potential problem for these brokerages that we just talked about is that their settlement agreements in Setzer Burnett and Morrell only reference home sellers, not home buyers. Batten 2 could result in the companies being dragged back into the fray. So just when you thought you're out, here we go again, right? So I don't suspect that that's going to happen, but I don't know. I think that would be a huge setback for what they've already thought that they've cleared. And I wouldn't think that they would have overlooked that. You would think. NAR doesn't have enough assets to post a $1.78 billion bond for an appeal. Assuming that the judge, leaves the jury verdict of $1.78 billion in place and denies the post-trial motions to set aside the verdict, NAR lacks sufficient assets to post a bond for $1.78 billion, which would be required to amount an appeal, much less $5.34 billion. So where's this number coming from? That's what the judgment was against NAR, against Berkshire, against the entities that we were talking about. So that's what's at stake here. But beyond that, there's treble damages. So that's where they get to the $5.34 billion. That $1.78 billion, that could be up to 3 times. Now, what they're saying here is that even if they wanted to, there's not enough assets on the books. Here's how much assets are on the books. They do have 1.0, which is still huge. And a lot of that has to do with the value of the MLSs and things of that nature. Total assets want a little bit over $1 billion, but the liabilities is $263 million. So although that's a big balance sheet, it's a huge entity. Let's not forget that. This being NAR, it still doesn't have enough to get all of that amount. So I do suspect that if they go on to appeal and do all that other stuff, I do think that's going to be substantially less than that. However, you never know. So again, we're going back to which entities would actually go bankrupt. I think it's going to be NAR that goes bankrupt. I don't necessarily see the other brokerages going bankrupt, even though the brokerages themselves and other MLSs out there or associations out there, they too don't have the money or capital to pay all of these fines and fees that are being assessed, or these fines that are being assessed. So you have state associations and publicly traded real estate companies don't have the money either. So they go on to explain, Bernice goes on to explain, the author of this article goes on to explain that here's how much assets they have. This is not even factoring in all of the liabilities and things of that nature. So simply, this is what they have on the books. This doesn't necessarily mean this is what they can come home to, this is what they can actually collect, because that's a big difference. So simply because something's valued at $105 million as an example, it doesn't mean you're going to be able to sell it for $105 million, especially in this particular situation, given that the commission the way that commission is being paid out in the future is very much in question, which this could be slashed in half. We don't necessarily know what the assets are actually going to be. Same thing here, even though this is the market cap at the close of whenever this particular snapshot was done. Well, here you see in 2023, this could very easily go even further. Again, it could go even further down, especially with the primary way that these companies generate revenue is jeopardized. So even though they're vastly under capitalized, even if they wanted to pay this extreme litigation against them, they're not going to be able to do that. One, because of they're already very low capitalized, or their cap rate is this. But even if they need to go out there and liquidate, they wouldn't be able to capture this full market value. All right, so this is something I really, really appreciated, because we talked about this within our real estate group. So in our real estate group, we have group masterminds. And as this continued to unfold, and as we continue to really talk about it and pivot, we needed to find different ways to approach this particular situation. So some of these commission models were some that we have explored, and some of us have actually put forth, because we do need to understand that things are changing. So we need to be able to adapt. So I'll share with you the ones that we looked at a little bit closer and the ones that we ended up going with. Agents who work with buyers exclusively. The National Association of Exclusive Buyer Agents, a group that only represents buyers, has served this specific market segment since the mid-1990s. So basically, a commission model here is agents that only are dedicated to being buyers agents. Think of these more like apartment locators. Apartment locators are phenomenal at that. They push the volume game there. The way that you do real estate with with apartment locating is a little bit different. So same thing here. Agents would essentially be specialists in the buyer side, and here it would require a bit more volume, more of a volume game. I certainly don't expect it to reach what we would consider a quote unquote normal or more traditional commission percentage. Exclusive buyer agreements. This type of contract continues to grow in popularity. Now, what I didn't know about this was I was under the assumption that buyer agreements were all across the entire country, because they are here in Texas and in several other states that our real estate group is in. So I've been familiar with buyer agreements, but that's not the case. This type of contract continues to grow in popularity, not only among exclusive buyer agents, but among agents who represent both buyers and sellers. The buyer's agent is paid a specific commission amount, regardless of whether any seller slash listing broker compensation is offered. Rocket Mortgage has an excellent discussion of how these agreements are, how they work, as well as facts you need to know about this type of contract. So again, exclusive buyer agreements, that's something that we've had here for the longest time, but it's not across the entire country. That was news to us. So while we always encourage buyer agreements to be signed from our agents, that wasn't done by every single one of our agents. So that's something that has become a necessity at this point. Fee for service. This is a model that we really explored in depth. This model unbundles real estate services to full service brokers provide and allows the buyer to select the services they want. For example, if the buyer is purchasing from a neighbor, but they need help navigating through the transaction and or obtaining a loan, they can hire an agent to provide these specific services. Real Estate Witch, powered by Clever, has a list of their top 10 fee for service real estate companies. So here, the way that this model was being explored, at least internally, was more on a consulting base, basically, where you can reach out to me almost like from an attorney standpoint. Obviously, we're not attorneys, but from a consulting standpoint, we would advise, hey, you're going to need to, here's what you do next. You obviously get under contract, you do an inspection, you do X, you do Y, you do blah, blah, blah. So basically just quarterbacking the deal without necessarily doing too much beyond that, right? So the fee for service model is something that some of our agents have actually started pioneering. One-party listing agreements for a single buyer. This model works especially well with off-market properties and for sale by owners. When there is little inventory, agents are desperate to find something to sell. Many experienced agents actively solicit one-party listings, a listing for a single buyer. For off-market and FSBO properties, the buyer agent is typically the exclusive agent of the buyer and negotiates a buyer commission that the seller will pay if the buyer's offer is accepted and closed. This particular model has been around for a while, but this is more of a strategy from the cold callers that would call FSBOs and essentially bring a buyer. Hey, if I bring you a buyer, Mr. or Mrs. Home Seller, will you pay me commission on that buyer? And many of the FSBOs that actually do that, many of the FSBOs that are out there, they would compensate the buyer at the buyer's agent at that point. So this has been around for a while, but it was more from as they're mentioning, off-market properties, but also for sale by owners. That way, well, actually expires as well, right? But for sale by owners, that way the agent has a in with that particular homeowner. Rebate models. HomeBay, it has a list of the top companies that charge 2% or less in commissions. In this model, agents from traditional firms agree to provide a rebate to the buyers. For example, Clever reports an average rebate of $3,000 for buyers or up to 1% of the agent's commission at closing. So essentially, at closing, you're going to credit something to the buyers. Now, this is something I've personally done myself, but not, it certainly wasn't something I was actively marketing out there. But it's a way to do it. It's a way to do it for sure. Buyer representations agreements must become the new normal. So this is where we get into it. The president and CEO of Calabra Technology, Cafano, said that approximately 14 or 15 states already have these in place and that he would like to see these adopted in all 50 states. This is where I actually learned that this was not a way that was done across the entire country. I was unaware of that, even though, again, I have agents in all 50 states at this point, and I was unaware of that. That was crazy to me. So that's a suggestion. Hey, what can we do? Make buyer representation agreements the new norm. All right, so what does this go on to say? The DOJ wins, contractual offers of compensation end as well. The buyer's agent commission field on the MLS is replaced with the seller concessions field. Okay, so what this essentially was that whenever you post a listing on the MLS, or whenever you post something on the MLS, you were required to put something that was not zero on the buyer's agent side. So you could put $1, but it just could not be zero. So here what they're saying is that field is going to go away if it hasn't already in the MLSs. And what is being suggested here from Ed Zorn, VP and General Counsel of the California Regional MLS, is to have a seller concession field, right? So the open seller concession field will allow the seller to specify if they want to directly pay the buyer's agent a commission, replace the carpet, give the buyer a credit towards closing, or any other concession or incentive they may like to provide. This is a viable approach that not only allows the sellers and buyers to determine which concessions they would like to buy, but in my opinion, would also be welcomed by the DOJ. So this is actually from their general counsel from the California Regional MLS. So that's what he's suggesting is make it known ahead of time. What is the seller willing to concede, as opposed to making it a blanket, what is being offered to the buyer's agent at this point. So here, what's the concession? And then also a suggestion that I have seen before, but I really hadn't looked at it all that much, was Zorn also suggested that residential agents take a cue from the commercial side of the business. Buyer agents should include the amount of their commission as well as any concessions as a standard part of any offer they present. So when that offer is presented, hey, this is what the commission is going to be, or this is what we ask the commission for the buyer side is going to be. So that's something that is done in the commercial side. All right, so here's where we get into the B word, the bankruptcy word. Because NAR has insufficient funds to pay the judgment in Sitzer Burnett, one of two things will happen. Ultimately, there will be some sort of national settlement, or NAR will be forced into bankruptcy. That's pretty serious, right? Based upon the conversation I've had with multiple experts, if NAR were to file bankruptcy, plaintiffs would be more likely to settle as opposed to dealing with the bankruptcy court. So here, again, if there's going to be an entity, I don't think this is the case, but if there was going to be an entity, I don't see the brokerages going out of business. I see NAR going out of business and going into bankruptcy. So again, I don't think that that's going to happen. And this is something that Bernice also doesn't think that it will be happening as well. But if there was one person left holding the bag, or one entity holding the bag, it would be NAR. So I do think that there's going to be some sort of settlement, something that will be substantially less than what's already been adjudicated, but we don't know. And something else to remember, though, I don't think I've mentioned this already, from the NAR not having enough assets, so NAR has insufficient funds to pay the judgment. So from NAR not having sufficient assets, something else to consider is that their professional liability insurance, that's been tapped out. We reported on that, I want to say 6 weeks ago or so. We reported that early on. No, it wasn't that long. It might have been 3-4 weeks ago. But from a insurance perspective, NAR has already tapped it out, and their renewal is coming up in May. Nobody's going to sign up to pick up that particular insurance, regardless of the premium. So from a professional liability standpoint, NAR has tapped out what it can do. And at that point, all of that was more about paying the attorneys. It wasn't even covering the judgment that was going to end up being forced against NAR. So that's something else to consider as well. From a lifeline, the lifeline of insurance is not there. MLS data should be available to all real estate licenses. This is something that has been suggested and basically is being done in all the settlements that have been written from all across the country. Agents do not need to be part of, can have access to the MLS without necessarily being part of NAR. Killing off the commission lawsuits will require one single national settlement. So they go on to propose or give a suggestion of a fee per transaction model. Here's a hypothetical outline of how that could work. Assume 5 million transactions, which is 10 million sites per year for the next 4 years. Agents on each side would pay a $100 transaction fee that would generate $1 billion annually and $4 billion over a 4-year period. Agents would participate based upon the number of transactions they close. So transactions, you're paying an additional $100. In terms of the payout, 2025 would pay off those sellers who transact during the year 1 of the agreement. 2026 would be for those who transacted in year 2, 2027, blah, blah, blah. All the money should go into a single escrow with the judge determining how much is allocated to the plaintiffs and to the attorneys the way it did in Anywhere and RE/MAX settlements. That number will most likely be 30%. So while this isn't perfect, this is at least, because there's no such thing as perfection here. It's you're doing the best with what you can. Ideally, you don't have to pay any of this, but this is a viable solution in my opinion. This is everyone's quick to critique, like, oh, this isn't going to work, or hey, this is perfect, or hey, this is just dumb, or whatever the case may be. But very few people actually come to the table with something tangible. Like with everyone's easy to critique, but when it comes time for you to have a solution to a problem, very few people ever pick up that check. Here, this is what I really appreciate about Bernice and the way that she writes, because she's providing as much information to you as possible and providing some viable solutions as opposed to just speaking from theory, which happens a lot. All right, so the problem with this approach, the biggest issue with this approach is that agents and brokerages who benefited from the higher commission rates are not necessarily the ones who would be responsible for paying the judgment. That's already been paid. That check has already been cashed. If I'm a new agent and I work for a brand that was not part of the litigation and then joined a brokerage as part of the settlement, why should I have to pay into the settlement? Viable point. If you have to pay through your brokerage, should you also be charged through your local or state associations and or NAR? This scenario could be a definite deal killer for many agents who can easily exit these organizations and still retain their MLS access. Right? So if you're not being required to join NAR at this point, and most likely the settlement is going to require that agents don't have to be part of NAR in order to have MLS access, well, don't be part of NAR and just have MLS access anyway. And if you're a member of NAR and you're being taxed with this particular setup, again, this is all hypothetical, then you're bypassing that potential fee. There you go. Now, this is what I really appreciate about this particular article. 3 reasons you should keep your NAR, state and local association realtor membership. It's easy to beat up on NAR. I've done it a lot. I fully admit that's something that the public sentiment with NAR is not all that high. It's very easy to just like taxes, right? It's very easy to say, oh, we're being overtaxed, blah, 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 right? Whether that's true or not, whatever. Or whatever your opinion is on that, that's what it's going to be. Same thing with NAR. We would all love for dues to be less, even though when you look at it in the grand scheme of things, if NAR would provide even a semblance of a benefit, which you're going to see right here, something that is very viable, just one feature alone actually provides its value, except we just don't heavily use it or leverage it to our benefit. If actually I'm going to go down a rabbit hole, so I will stop. So think about this. So again, she's giving you 3 reasons you should keep your NAR, state and local association membership. So NAR dues as of 2024, $156 per member. Part of that goes on to lobbying. Part of that goes on to the fund and all that other stuff. So you could pay thousands. Where is it? Okay. One of the things that she brings up is RPR. RPR is phenomenal. I don't know if you've ever clicked on RPR and gone through their market reports, have gone through their CMAs, have gone through their comparative analysis. It's really, really cool. You could pay thousands of dollars just for the market intelligence reports for all the property research this site provides, plus for the training that shows you how to use this powerful tool to immediately convert leads by using RPR. Tell you, RPR is legit. I've in my marketing channel, Jaime Resendez is my name. I have a marketing channel that I go and I show how to actually do a CMA through NAR. Now, this video was years and years ago, about 3-4 years ago, but it still gets some of the most high views in that particular channel. Not because of the video, it being good. I would argue it wasn't good, but the tool is that good. So you have a lot of people still using it. In my opinion, RPR, especially for new agents, is worth significantly more than $156 per year. And I can't say I disagree. It's got a lot of valuable utility, protecting personal rights and independent contractor status. So basically, it goes on to the lobbying component. How effective that's been, I personally don't know. Expanding home ownership, how effective that's been, again, I personally don't know. They'll make the claim. So NAR actively promotes making homeownership available to more people through affordability, fair housing, and initiatives that help more people become homeowners. The one thing that I do know about NAR is that they made a video, they made a series. I think it might be called The Homeowner, or something like that. They made a series, homeowner series, that's actually pretty well produced. I'm not gonna lie, it's actually pretty well produced. It might be on Hulu. I'm getting an email. This must have been 2 months back. Them announcing that, like, hey, it's season 2. I didn't even know there was season 1. And I remember messaging into our group Slack for our agents at the Agent First group, asking, hey, did any of y'all know that we had a show like through NAR? None of them knew. And we have hundreds of agents. None of them knew. So whether anybody else watches it, I don't know. But I'll backtrack. Expanding homeownership, just for that show alone, I'll go ahead and say yeah. Other member benefits. Outside of the travel and rental car, I really don't have much experience with the others. So DocuSign, yes, there's a discount. FedEx, I have not used the FedEx discount. I need to look into that. Marketing and printing materials, I don't do all that much. And the websites, I generally create them myself. Really, the travel and car rental are the ones that I've personally explored beyond that. But there are some benefits, even if you can get a 10% discount, 20% discount, 30% discount on any one of these things. I do see these being as valuable. Certainly, you can make your money back of $156. It's not that big of a due per se. So I do appreciate where she's coming from. Overall, I do think that this is something that obviously there's a lot of things that are undefined. 2024 is going to it's super, super important, because there's a few more questions that are going to get answered. You have these verdicts that are continue to happen. You're going to have all of the you saw in April, there's going to be the final or essentially how much is going to be paid, or if anything else is going to happen. There's still the appeal and everything going on with the main lawsuits. But at the end of the day, 2024 is going to be a pretty big year for everybody involved. This point, we as agents need to start pivoting, because there is going to be a change. There's no question about that. So we really can't be caught flat-footed. That's the one thing that we can't do. Inaction is not an action. It's not an option at this point. So there has to be some sort of change that happens in your business. But let me know what you think. Let me know what's going to happen in your eyes. What would be something that you would consider a win? What's the most likely scenario that's going to happen as a result of these commission suits? Outside of that, I'll see you tomorrow.